All right, it's 1 o'clock, so let's get started. I will share some very brief housekeeping notes before I turn it over to Judge Stein to welcome everyone. We have sent you all CLE forms and program materials by email. So if you're seeking CLE credit, please stay tuned for the 2 CLE code words that we'll be sharing during the program. If you have questions about obtaining CLE credit, please email Lisa Rivage, and I will put her email address in the chat. But for those of you who are listening on the phone, her email is lriva@albanylaw.edu. If you have questions throughout the program for our guest speakers, you can type in your questions using the Q&A box at the bottom of your Zoom window. If you have any additional questions or concerns or having trouble hearing us, let us know in the Q&A box, or you can email me separately at cmill@albanylaw.edu. Live automated captioning is enabled for this program if you're joining on your computer or mobile phone or tablet. To view the captions, you will click Live Transcript at the bottom of your Zoom window, and you can select either Show Subtitles or View Full Transcript. Thank you all again for joining us, and I am happy to pass off the baton to Judge Stein.
Thank you, Shea, and welcome everyone to the 5th and final installment of the 2023 Disability Law Series on Civil Rights and Individuals with Developmental Disabilities. I'm Leslie Stein, Director of the Government Law Center and home of the Institute on Aging and Disability Law. As you might expect, these programs have been organized by a number of individuals. Special thanks to the members of the Aging and Disability Law Committee, members Lawrence Faulkner, Paul Kietzman, and Sheila Shea, led by our own Professor Rosemary Bailey. Also, many thanks to the GLC staff members who have handled the arrangements for this program. The prior programs in this series have included an overview of civil rights and people with developmental disabilities, as well as discussions about consent in healthcare decisions, consent of adults in adoption and marriage decisions, and finally, challenges in guardianship and strategies to address them. Today's program will draw from each of the previous discussions and will address potential statutory reforms to better protect the civil rights of people with developmental disabilities. We are very fortunate today to have as our moderator, Jennifer Monthie. Ms. Monthie is currently the Legal Director for Disability Rights New York. She has an impressive history of working with and advocating for individuals with intellectual and developmental disabilities and protecting the civil rights of individuals with disabilities. I commend it to you and hope that you will review her bio that is included in the program materials, but I will now turn the program over to her so that we can hear from all of our panelists. Thank you again for joining us.
Thank you very much for that wonderful introduction, Judge Stein. So I have the pleasure of introducing your panel today, which I'm going to very briefly do, and then each of the panelists are going to take a few moments to give you an introduction of their subject matter for the later panel discussion. So today I'll begin by introducing Rosemary Bailey, who is a consultant for the Institute on Aging and Disability Law with the Government Law Center at Albany Law School. We also have with us Robert Swidler, who's General Counsel at St. Joseph's Health and St. Peter's Health Partners. We have Paul Kietzman, who's a counsel at Barclay and Damon. And finally, we have Sheila Shea, who's the director of the 3rd Judicial Department of Mental Hygiene Legal Services. So we're going to begin today with Rosemary Bailey. If you'd like to take us through your topic today.
Thanks, Jennifer. I'm going to share my screen because I have a few slides that I'm going to use for the discussion. Here we go. Okay, from the beginning. So I'm going to focus on guardianship, particularly Article 17A, guardianship for people with intellectual and developmental disabilities, which is found in the Surrogate Courts Procedure Act and its legacy up to today. I think we're fortunate that the topic of guardianship has sort of entered the national conscience through the Britney Spears issues in her conservatorship in California. We also have an op-ed in the New York Times Union this morning talking about guardianship and the need for services for low-income individuals. So this topic is timely on so many levels, but particularly we're going to focus on its impact on people with developmental disabilities. And so to put this all in context, I want to alert everyone to the fact that the mental hygiene law states as a policy of the state of New York that it's to promote the independence and self-development of individuals with developmental disabilities. And in fact, the regulations of the Office with People with Developmental Disabilities says that a person's diagnosis of a developmental disability shouldn't deprive them of their civil rights. So I think as we look at Article 17A, we'll see that it may not be quite the case with respect to the statute. So I'm going to talk about the history of the statute, what it looks like in general, and then the legacy that it has on individuals, the courts, and policymakers. And we'll get to how things might change later on in the discussion. The materials with respect to the slides and some other statutory materials are in your CLE packet. So Article 17A was enacted in 1969 as an addendum to the guardianship statute for minors, which is found in the Circuit Courts Procedure Act. And it's emphasized by the fact that the provisions of the guardianship for minor statute are applicable to all proceedings under 17A unless there's a direct conflict. At the time the statute was introduced and enacted, the Association of Retarded Citizens included a memo that said that this provision would provide for a lifetime guardianship for a retarded individual to eliminate the cost and complications caused by a separate proceeding in a separate court. What this points out is not only that it was anticipated this would be a for-life guardianship, but in fact, at that time, New York already had a guardianship statute. It was called a committee statute, but same idea, same purpose, that was for people who could not make decisions for themselves. But 17A became a separate statute for individuals with developmental disabilities. In 1989, the language developmental disabilities was added to the statute, as was coverage for people with traumatic brain injury. And we'll see that actually has a peculiar effect on the statute in a few minutes. So under the statute, the standard for determining whether or not an individual needs a guardian is the best interest standard. And as this case, Robert C.B. that I have on the slide mentions, it's an amorphous standard and it's very discretionary. And that Robert C.B. case, I urge you to read because you can see how a statute that uses best interest can lead to very unusual results. In that case, Robert C.B. had a car loan that he took out that was more than he could handle financially. And the court concluded that he couldn't rid himself of his guardianship for financial affairs because he was under this loan and he apparently didn't know how to take care of it. As the appellate division found, he certainly did know how to take care of the loan by managing his finances, and the court reversed the lower court's refusal to get rid of the guardianship. There was no mention of any alternatives to guardianship at Article 17A when it was enacted, nor today. And as time has passed, we have healthcare proxies and powers of attorney and recently supported decision-making, a number of ways that people can arrange for decision-making when they do not have capacity to do it for themselves, but they're not in Article 17A. The appointment of the guardian is for an indeterminate period of time. As this section that I have on the slide points out, it doesn't terminate when the person reaches the age of majority, which clearly it contemplates the idea that someone might seek a guardianship for this person while they were a minor on their marriage, but shall continue during the life of the person or until terminated by the court. I emphasize the word marriage because when we were listening to Ed Wilsinski at our last program, it sort of dawned on me in a flash, wait a second, if a person is alleged to have a developmental disability but they've gotten married, don't they have capacity to enter into marriage, which is a contract? And so how does that work? But there's really no explanation of this. And also, there's no monitoring of the guardianship post-appointment unless the individual has assets. And for many individuals who are subject to an Article 17A guardianship, there are no assets to be considered. So in 1989, there was the amendment to 17A to include the term developmental disabilities and to make a few minor alterations. In 1990, the legislature passed and the governor signed a law directing OPWDD to look into guardianship under Article 17A because of the vast changes that occurred in thinking about individuals with developmental disabilities and in thinking about the protection of individuals who might be subject to guardianship. That was in 1990. It's not revealing any secrets to say that OPWDD never issued an official report, but in 1995, a draft report began to circulate that pointed out that Article 81 would actually be a better guardianship statute, but nothing happened. In the meantime, the legislature in 1993 passed and the governor signed Article 81 of the Mental Hygiene Law, which was an overhaul of that other guardianship statute that was in place when Article 17A was carved out. And the legislature found, as you can see from this slide, that individuals with incapacities have unique needs. It shouldn't be a one-size-fits-all. It shouldn't be indeterminate time. It should be what they need. And so the statute looks towards providing the least restrictive form of intervention for the individual that allows them to exercise independence and self-determination. Sounds familiar, right? Talks about what the mental hygiene law already said about individuals with developmental disabilities. And by the way, Article 81 applies to anyone who's alleged to need a guardian, including someone who has a developmental disability or an intellectual disability, but the statute isn't driven by the diagnosis. They're rather driven by what the person needs. So Article 81 provides that alternatives to guardianship should be considered, that counsel should be appointed. And interestingly enough, when the Kennedy administration issued its report for the panel on mental retardation back in the late 60s, they had a number of things to say about guardianship. And one of them was that a person with a developmental disability or at that time mental retardation should have appointed counsel. But we don't see it in 17A. Article 81, the guardianship's authority is tailored to what the person needs. And the standard by which a person is determined to need a guardian is clear and convincing evidence, the highest civil standard for such an appointment. And there's periodic review of guardianship restraints. So we have two statutes now. We have Article 81, as you've seen, that's tailored, that's designed to promote self-determination, that includes guardianship review, has counsel appointed, and looks to the least restrictive alternatives that the individual can use. So what is the legacy for individuals now with developmental disabilities? Article 17A has a laundry list of conditions described as developmental disabilities. What's interesting about that is certainly developmental disabilities is a term of art that's used in federal legislation and in state legislation to figure out whether people might be eligible for services. But when you read the list as it appears in Article 17A, you might wonder, is everybody the same? Just because they have a developmental disability doesn't, I think, mean that. The statute standard best interest, I've already mentioned, is a discretionary determination. A hearing for the appointment of the guardian is not always required. If family members are seeking the guardianship, the court can dispense with the hearing. And there's no stated standard or burden of proof. Now, I put up these two quotes because I happen to think they inspire us to think about what it means to have a standard of proof. In Addington v. Texas, the United States Supreme Court said that having one is more than an empty semantic exercise. In cases involving individual rights, see guardianship, the standard of proof at a minimum reflects the value society places on individual liberty. And in our own Court of Appeals, Rivers v. Katz, the court said the sine qua non for the state's use of its parens patriae power, see guardianship, is a determination that the individual lacks capacity to make decisions. That determination is uniquely judicial, not medical, as to whether the person has capacity, and the state, see petitioners, should bear the burden of demonstrating by clear and convincing evidence the patient's incapacity to make treatment decisions. The continuation of the legacy for individuals, there's no right to counsel. There's no choice as to which statute is applicable. So we have two statutes, Article 81 and Article 17A, with different standards of appointment, different terminations of appointment. Under Article 81, the court sets a termination date, yet the petitioner, not the individual, not the respondent, makes the choice. Well, you say, well, that makes sense. The petitioner is seeking the guardianship, but there's no procedural remedy for the respondent to get out from under the fact that they may be subject to a statute that doesn't provide the kind of protections that Article 81 does. And in preparing for this, I came across some writings that pointed out that, in fact, Article 81 is a less restrictive alternative to Article 17A. So I thought that was an interesting comment to make. The legacy for the courts is there's an uneven application of due process rights independent of the statute. Because the statute doesn't lay these things out, many courts have taken to applying standards from Article 81 to the statute. And that sounds great, but there's two drawbacks, I think. One is it's uneven because you're really not clear which court is going to do what. Secondly, even within a particular case, and I'll point back to Robert C.B., the court may not do wholesale application of Article 81 standards. In that case, Robert was seeking to have his guardianship terminated. Under Article 81, the person who objects to that termination has the burden of proving that the guardianship shouldn't end. Under 17A, there's no standard and no burden is mentioned. And so the court applied the traditional burden, which is the person seeking relief has the burden. And so you have a person who's under this guardianship having the burden to show they no longer need it. And what's added to this, and I know Jennifer could mention this as well, is because there often hasn't been a hearing, the record for trying to terminate the guardianship is very incomplete and often serves as a barrier to getting rid of the guardianship. And finally, the legacy for policymakers. Trust me, I could go on for a long time on this, but I'll be short to say that for the last, since 1990, so how many years is that? People have been trying to reform Article 17A and nothing has happened. It's still an addendum to guardianship for minors. People with developmental disabilities are treated differently. Efforts at reform have stalled, even though I could go through a laundry list of options for change that are recognized by the courts, see the cases we just discussed, as well as policymakers. On the other hand, there have been several amendments to various legislation, various statutes in New York law, taking out the word mental retardation and replacing it with developmental disabilities, one as recent as a year ago. So it's not as though people are not aware of the needs, but their choice is to just tinker with language. And I think sort of following up on that legacy also, and Robert's going to talk about this in greater detail, Section 1750B of the Surrogate Courts Procedure Act is a healthcare statute. Now, I ask you, how many times elsewhere in the Surrogate Courts Procedure Act are there healthcare statutes? Usually we find them in the public health law, but because the treatment is different, the statute winds up there. And Paul will talk about the Act Now Healthcare Proxy, which is again an effort in stalling. And finally, supported decision-making, which is on everybody's lips because it just passed in 2022 in New York. And it has certainly a lot of merit to it, But in passing that, the legislature totally ignored the fact that people who need a guardianship and who want to have a guardianship don't have the protections that they would otherwise have under Article 81. I'll stop now, Jeff. I'm getting too excited.
Thank you very much, Rosemary. All right, we're going to turn to Robert Swidler now to talk about the Family Health Care Decision Act and healthcare decisions for people with developmental disabilities.
Actually, I need to interrupt very briefly to share the CLE code word. So I'm going to share my screen very briefly, and then Robert, I will pass it to you.
Okay.
For those of you who are seeking CLE code words, your first code word is proxy. This is something you'll hear throughout the program today. That word is proxy, P-R-O-X-Y. If you're joining us on your computer, you should be seeing it on your screen. Again, that first CLE code word is proxy.
Okay, that's very apt. Are you able to return the screen to me, or I got to share again? Hold on.
You will have to share it again.
Okay. And now I've lost my PowerPoint. There it is. Is everybody seeing my slide?
Yes, we are.
Okay, very good. So I'm very happy to be here today. I'm going to be making the case for extending the Family Healthcare Decisions Act to cover people with intellectual and developmental disabilities. It was really helpful for me to listen to Professor Bailey's presentation. It's almost a perfect segue to this because she is making the case for extending Article 81 guardianships to people with intellectual and developmental disabilities, basically to treat them like other people who lack capacity through the same protections and process. And I'm making a parallel argument to extend the Family Healthcare Decisions Act to persons with intellectual developmental disabilities, to make them subject to the same statute that governs healthcare decision-making for people who lack capacity, for other people who lack capacity without developmental disabilities, with some additional safeguards drawn from their current statute and regulations. And so it is really the same case for reducing the disparate treatment of people with intellectual and developmental disabilities. As just a quick background, I'll skip this list of issues. There's really a slide on each one. To give you some quick background, prior to the Healthcare Decisions Act for people with intellectual and developmental disabilities in 2002, the basic principles of end-of-life decision-making, I'm focusing on end-of-life decision-making in New York, where adults who had capacity had very broad rights to make decisions for themselves. That was always true. It's still true. That's not really an area of great contention. For adults who lack capacity, as of 2002, life-sustaining treatment could be withdrawn or withheld if they had made a prior decision before losing capacity, either by writing it in a living will or other document or other clear evidence, sitting up in bed and telling people, I don't want this treatment. That's a valid legal way to do it as of 2002, or to write a healthcare proxy. We had the healthcare proxy law by that time, where you could appoint somebody to make decisions for you in the event you lose capacity. So those pieces of advanced decision-making were in place. We also had the beginning of a surrogate decision-making law, but only for do not resuscitate orders, only for the advanced directive that says if my heart stops, don't come in with equipment and defibrillators and so forth and make an attempt to start it again, which makes sense when you're dying from some underlying disease, and resuscitation's not going to impact that. But no other surrogate decisions were lawful. There was no ability for unappointed family members who weren't appointed under the healthcare proxy law to make any decision for regarding end-of-life care. This became particularly noticeable for people with intellectual and developmental disabilities. It's a famous case out of Syracuse, the Sheila case in 2002, where family members were not able to make a decision for a dying patient with an intellectual disability, with a developmental disability, because she had never given clear and convincing evidence of her own wishes. She was never able to, because she had always been developmentally disabled. So that was seen as particularly egregious, that there was no opportunity for this population to give an advance directive or make their wishes known. And the legislative response to that was this Healthcare Decisions Act in Surrogate Court 1750B, which is laudable in many ways, and did provide the ability to make surrogate decision-making for end-of-life treatment for people with developmental disabilities. There were plenty of safeguards in it. It had to meet clinical criteria. There were provisions about determining incapacity, about selecting the surrogate, and it was a great advance and was a model for, to some extent, to later legislation itself. It drew a lot from the DNR statute, but is structurally different from it. Meanwhile, the general population didn't have the ability to have surrogate decision-making unless you appointed a healthcare agent. And that was an enormous gap. There were cases that would arise quite frequently in hospitals where a patient was dying, lacked capacity. Family didn't think that, thought there should be comfort care only, and life-sustaining treatment should be discontinued. The doctor recommended it. The hospital thought that made sense. Ethics consultants thought that made sense. A court would have thought it would make sense if they had the ability to authorize it, but they did not. Under governing principles, nobody had the authority to authorize the withdrawal of treatment. That was until 2010, when the Family Healthcare Decisions Act was passed. It empowered family members or a close friend, there's a surrogate priority list, to make healthcare decisions when a patient lacks capacity, didn't previously decide for themselves. If they did, you don't need a surrogate, you go by that patient's decision, and didn't appoint a healthcare agent. If they appointed one, then you go by the agent's decision. And it included both consent to treatment and decisions to withdraw with whole life sustaining treatment. But it deliberately omitted people receiving OPWDD services because they had their own law and it was complex figuring out how to reconcile that. It also didn't apply people who were transferred in from mental health facilities because it recognized a need to perhaps integrate special provisions for that population as well. But I think I'm going to talk about this later. The last provision of this chapter directed the task force on life and the law to study this issue and make recommendations. So I'll come back to that in a minute. So there are now two laws for end-of-life care for people with in New York. One is for people with developmental disabilities, 1750B, and one is for everybody else who has loses capacity and did not previously appoint a healthcare agent. So what are the differences between those laws? Slight differences on lots of different topics. Slight differences on how you determine incapacity. One has a presumption that you have capacity until there's a determination otherwise, the other doesn't. It has slight differences in the qualifications of the professionals. It has slight differences in the surrogate list. The 1750B has a requirement that the surrogate has to have been involved in the life of the patient. This Family Healthcare Decisions doesn't. The role of the spouse has a lower priority in the 1750B than it does in the Family Healthcare Decisions Act. Slight differences in the language of surrogate decision-making standards, slight differences in the clinical standard. You can see a theme here that I'm hammering out. They're just slight differences everywhere you turn. Slight differences in who gets a notice of it and what their rights to object are. So what's the practical effect of 25 different slight differences between these two laws? I've seen this my entire career, and particularly during COVID. We have an ICU that has 20 beds in it. 19 of them have people without developmental disabilities. One has a bed with developmental disabilities. They see end-of-life issues day in, day out, all the time. If you look at COVID, and most of these are people in early COVID dying from COVID, the staff is very, very familiar with, knows the rules, knows what they got to do for those 19 patients who are dying from lung disease or kidney disease in connection with COVID. They know the forms, they know the process. They get to that 20th person with a developmental disability, and we got to call our counsel. We're not sure who we notify about this. We're not sure what the standard is. We do have a policy. Could somebody go look that up? Causes confusion, disruption, delay. liability concerns, calls to hospital counsel, and general disparagement of the law. Why? Because they're looking at this. Why is there a different standard for the surrogate? Why is there a different standard for determining incapacity? Some of them make sense. A lot don't make sense. They just don't have a strong or strong enough defense for a separate rule to justify the confusion and disparate treatment that they cause. So, and I put here, worst of all, they just cause disparate treatment, and non-standardization is not a good thing in this kind of situation. So I mentioned earlier, when the Family Healthcare Decisions Act was passed, there was no intent for it to permanently exclude these populations. It was just looking for a way to carefully bring them into the scope of the Family Healthcare Decisions Act. So the law that created it had a provision in it that required the formation of a special advisory committee to make recommendations on whether the Family Healthcare Decisions Act should be amended to apply to this population. And that special advisory committee was formed. I was one of the members of it. The former OPWDD commissioner was a member of it. It cataloged it really did a great job here, and I recommend its report to you. It's very thorough and comprehensive. It cataloged every difference between 1750B and the underlying OPWD regs and the Family Healthcare Decisions Act. And in each case, in a chart, proposed a reconciliation, either adopt the Family Healthcare Decisions Act approach, or in some case, add a provision similar based on or similar to 1750B into the Family Healthcare Decisions Act. For instance, notice to MHLS was not something that you get in the Family Healthcare Decisions Act. They recommended adding that into the proposed merger in Family Healthcare Decisions Act. So it proposed retaining special safeguards for end-of-life decisions for people with IDD, including that role for MHLS. So I've heard policy arguments for doing this and against it. Obviously, I'm a proponent of it and advocate for it. I'm getting older and tireder, so I'm hoping that there's somebody in the audience here that wants to pick up this banner and make this case. But the arguments for it are we would eliminate the confusion, disruption, delay, liability concerns, calls to hospital counsel, disparagement of law if we streamline this process, which is now just patchwork and unequal treatment. We'd reduce the unequal treatment of people with IDD, and we'd make New York end-of-life law less chaotic and complex than it is now. The con is that I keep hearing that the organizations and for people with developmental disabilities say that those families are familiar with the Healthcare Decisions Act for people with IDD and are comfortable with it and don't really see a need to change. Well, you don't see a need to change until you end up in the ICU, and that's when the problems occur. That's my argument about that. They'll have to learn slightly different rules. That's one generation that would have to learn those slightly different rules. And the MOLST form would have to be revised because right now there's a lengthy special provision for people with developmental disabilities, and it would start to look more like the MOLST form for everybody else. So that is my case, and I'm impressed that I ended this 1 minute early, but I'm looking forward to the discussion on this, and we'll take it from there. Thank you.
Thank you, Robert. All right, we're going to now go to Paul Kietzman, who's going to talk about the Act Now healthcare proxy.
Thanks. Hi, all. Pleasure to be here. I'm in the process of cleaning out my office here. I think I might have come across a pair of Jimmy Hoffa's cufflinks under a pile of files a while ago. The only thing I would add to what's in my bio is that for 27 years, I was the first and only general counsel at what was then OMRDD. And then for about another 6 or 7 years after that, I went and was the general counsel for the Arc of New York, NYSARC Inc. So I drag behind me as I present to you like the chains that I forged in life, like Jacob Marley's ghost. And but I'm kind of running out of energy to argue against a lot of the things that are being presented here today. So as far as Act Now healthcare proxies go, it is, I think, in need of legislative reform, but there has been on the books since 2008 a chapter law that would have authorized the demonstration project implementing Act Now healthcare proxies in the residential service system operated by OPWDD, operated and overseen by OPWDD, but it's never been implemented. And to be honest, I think that the panelists in prior panels have convinced me that doing things specifically for people with developmental disabilities is possibly contrary to non-discrimination theory. And so I think really what deserves some consideration now is permitting a box to be checked on healthcare proxies that indicates that the agent can begin acting now. And I'll explain that a little bit. I think there are like three concepts that bear discussing, and they're kind of cumulative of things we've discussed before in other panels. And they go, in my view, as follows. First, there's a difference between capacity and competence, although sometimes they wind up being used interchangeably. One of our esteemed colleagues, and I know most of you know him, a clinical psychologist by the name of Marty Layden, said, capacity is a state, not a trait. And what I guess he meant by that is that capacity is kind of transaction specific, and it can't really be determined outside of a factual, a factual context. Competence, on the other hand, sometimes used interchangeably with capacity, has more of a permanent connotation. And the public health law, the portions of it that define healthcare proxies, use the term competent in terms of the ability to create a healthcare proxy, and they use the term capacity in the context of when an agent's authority commences. And I think they use them properly in that sense. So at any point in time, a person can either have or lack competence in the legal sense to execute a legal document. So, and so, since capacity is transactional, it seems to me that a person on a given Thursday afternoon in April could have the competence to execute a healthcare proxy, and on that very same afternoon, on a Thursday, could lack the capacity to fill out on their own a most form. So to some extent, I think the existence of healthcare proxies in their current form in the statute are not particularly suited to people with developmental disabilities. I think most practitioners agree, and I think we've had prior panelists state this, that the level of competence to execute a healthcare proxy is towards the very lower end of that intellectual wherewithal that's necessary to execute other legal documents like a will or a general power of attorney or a deed, that sort of thing. Previously, OMRDD and also OPWDD in their booklet, Healthcare Choices, which I think is in the process of being rewritten now, they've described it simply as the ability to understand that a person, the principal, is conferring on a person they trust the authority to make healthcare decisions under certain defined circumstances. And as a general rule, informed consent is relevant only in non-emergency kinds of circumstances, although the most form expressly allows a healthcare agent to go through the execution of it, and the most form describes itself as a process or a document that should be considered at a point in time where a person's level of illness threatens their lives. As all of us who are lawyers on panels, and for those of you who have tuned into prior of these panels, You know that the model healthcare proxy that appears in the public health law, section 2981, is written in 12th grade English, and it's a springing and therefore durable power of attorney. And what that means is that the agent doesn't have power to make decisions until the individual, the principal, has been deemed in some fashion or another, the statute in some cases describes how, has been determined incapacitated to make their own healthcare decisions. And the thing that's troubling about that, in addition to the fact, as I mentioned, that a person could be competent on a given day to execute a healthcare proxy and already incapacitated to make certain healthcare decisions. And so the thing that bothers me, particularly in the context of people with developmental disabilities, is there's at that point in time, when the person has been determined incapacitated to make their own healthcare decisions, there's only one conditional opportunity at which a physician has to talk to the principal or the patient, and we'll talk about that a little bit more later, time permitting. So anyway, physicians make these determinations of incapacity at the time a decision is needed, and usually in a hospital, which is where the number of doctors or clinical psychologists necessary to effectuate the decision are usually found. In the case of a patient or a principal whose disability is deemed to result by the attending physician from a developmental disability, the attending physician then has to get that determination confirmed by either a physician or a clinical psychologist who either works in the OPWDD system or who has, by virtue of education, training, and experience, meets certain criteria that are set forth in statute and regulation. And of course, it's also not at all uncommon, especially when you're talking about hospital situations, that disease itself or some of the psychoactive medications that are used will affect a person's capacity. So that determination should take some time. It should certainly involve some examination of the patient by the people that are involved in the determination. And the patient is entitled to notification of that one determination that he or she lacks capacity, but only where the physician thinks that the patient, the principal, can comprehend that disclosure. I don't know how that works, to be perfectly honest. In the case of a patient that was transferred to the hospital or who confronts the physicians and was most recently in a residential facility, the executive director of the facility is also entitled to be notified. And we kind of hope that that person will, by virtue of their familiarity, hopefully long familiarity with the individual and their capacity, will have a point of view that can be expressed. So also, under the existing statute, the patient or principal can revoke the authority of the agent in writing, orally, or by any act evidencing a specific intent to revoke the proxy. But, I can't help wondering, how does a DD patient learn of that ability? Since there apparently is no duty, although I would hope that physicians do it, to inform the individual of what the agent has decided following the determination of incapacity. The public health law 2991 directs the OPWDD commissioner to promulgate both educational materials and regulations that discuss the issue of healthcare proxies. And there is a regulation that's been on the books for quite some time, 14 NYCRR 63320, which tracks the public health law almost directly and delegates the responsibilities for educating, informing, and overseeing healthcare proxies and healthcare agents to executive directors of agencies. The PHL presumes that everyone is competent to execute a healthcare proxy unless that person has a guardian, but 17A was amended, I guess, back in the 2002 amendments. And it now requires a guardianship order issued by a surrogate to address a ward's capacity to make healthcare decisions for him or herself. Capacity, I think, there is the wrong term. I think what they're inferring is that you are supposed to evaluate an individual's competence, which in some cases is clear and in many other cases is a little bit more equivocal. And even then, the rest of 1750, including 1750B, it remains understood that capacity is a state and not a constant. And the decision-making standards for guardians and healthcare agents are virtually identical in between the two statutes, but the responsibilities and identities of the parties that are involved are somewhat significantly different in that the involvement of MHLS and OPWDD, and in end-of-life healthcare decisions, the requirement of direct knowledge of a principal's wishes as to nutrition and hydration by means of medical treatment. Both the public health law and the OPWDD regulations have special requirements for a resident to execute a healthcare proxy. One of the witnesses must not be associated or with or employed by the facility, and one of the witnesses must be either a doctor or a clinical psychologist, again with those same employment or training and experience and education qualifications specified in the statute. An officer or an executive manager or an employee of the facility in which the individual is served cannot become that individual's agent. And I think the wording of the regulation is meant to allow for the possibility that a non-managerial employee who works in a facility separate from the individual, but for the same provider, can act in some cases as a healthcare agent. And I don't know, I guess we'll have to check with OPWDD on that. So generally, in the couple minutes I have left here, I want to explain how an Act Now healthcare proxy would work. All of the execution and duties and responsibilities of the agent, means of revocation, the limitations depending upon knowledge of wishes for artificial nutrition and hydration, all of those things remain in effect, but the right of the healthcare agent to receive healthcare information would commence immediately with the execution of the Act Now proxy. The healthcare proxy is then entered in the individual's clinical record, and it's given to his community physician and perhaps other clinicians. The agent and the principal, when treatment is proposed, go to the doctor's office together. They sit in the waiting room for 45 minutes or an hour, just like all the rest of us do. Eventually, they get to go inside and sit down with the doctor. The doctor explains to both of them the risks, benefits, and alternatives to the treatment that's being proposed. The agent and the principal confer, and ordinarily they would probably agree that the recommended course of treatment would go forward, and the doctor is obliged to record all of those conversations and the decision where there is a concurrence in the individual's record in the doctor's office. If the agent and the principal wind up in disagreement, the principal, as in the current public health law, the principal's decision prevails, and of course the principal can discharge the agent. But both the public health law and the OPWDD regulation authorize certain parties in interest to the proceeding to commence a special proceeding which can be invoked to resolve disputes of one kind or another and to override the decision of a healthcare agent regarding healthcare treatment for the principal. There is no mention of overriding the decision of a principal, and that, it seems to me, is perfectly appropriate. And there's no elucidation of what override means. In other words, override, it seems to me, would permit the inference that the reviewing court could make a different decision. But I kind of hope that's not the case, but it's not clear. And the other interesting thing is who can initiate a proceeding to review, resolve, or override the healthcare agent's decision. The statute and reg both provide a list which includes conservators and committees. And as they say in New Orleans, who dat? They don't exist anymore in statute anywhere, but they exist in regulation, I guess. More significantly, healthcare providers can initiate these proceedings, family members, close friends as defined in the Family Healthcare Decisions Act, as well as the commissioners of health, OMH or OPWDD. Notably, a healthcare agent cannot initiate a review or request to override the principal's decision, nor can the principal themselves initiate a special proceeding. There's no rule for MHLS, although if MHLS knows about this, I think they have jurisdiction under the mental hygiene law to get involved. And the last point I want to wedge in here in my dying moments is we can talk some more about why I think this is advisable for everybody and why the existing healthcare proxy statute is a little bit unfair or not as workable as would be desirable for people with developmental disabilities. We've spoken about the new supported decision-making statute. One of the things that has caused me a discomfort about that statute is the fact that the statute, I think, at least leaves open the interpretation that the assistance of a supporter can be utilized in determining the capacity of an individual to make their own healthcare decisions. That seems to me to undercut existing principles of law, but that's fine. The supported decision-making statute would not let a supporter act as a surrogate to make healthcare decisions, and that's also perfectly appropriate. But it seems to me that an Act Now healthcare proxy, as I've tried to outline its general functions and that sort of thing, is a natural fit, completely congruent with the Supported Decision-Making Act. You could very, very easily, and perhaps it would be a mistake to do otherwise, appoint your supporter as your Act Now healthcare agent and go forward and make those decisions. And the thing that I think in practice, as you think about it, and I could argue it some more, adding an Act Now option to the statute and executing such a healthcare proxy really obviates the question of an individual's incapacity, because if determined to be incapacitated, they can make their own decision in this. They can fire their healthcare agent, they can make their own decision, and that decision cannot be the subject of a proceeding to override, as I understand it. And that's it from me. Thank you.
Thank you, Paul. All right, we're going to start with our last panelist's presentation, Sheila Shea on adult adoption.
Thank you very much. I'm going to provide some foundational material because we had an extensive treatment of adult adoption. I think in our third civil rights forum, we devoted our 2 hours to adult adoption and marriage. So today what I thought I would do is provide some additional background regarding adult adoption, and then focusing on the case that was the subject of a Court of Appeals review matter of Marion T. And then towards the end of my remarks this afternoon, I'll talk about some potential ideas for legislative reform. So we'll just get to the foundational material here. Again, the discussion of the case of Marion T. provided a really robust foundation to think about adult adoption in New York. Marion was a person, or is a person, with intellectual disabilities. At the time the case was litigated, she was 64 years old, and she lived in a family care home under the auspices of the Office for People with Developmental Disabilities. And the case centered on whether she was the proper subject of adoption. So that implicated our statute in New York, which is found in Article 7 of the Domestic Relations Law, which creates the legal status of adoption and regulates how that status may be established. Next slide, please. So the adult adoption statute is in New York is broken into 4 different articles, and we were focused on Title I. Next slide, please. Any statute that we analyze, the definitional terms are important. And of course, I just want to back up a bit and say that the Marion T case was a case involving statutory construction. It did not implicate there were no constitutional claims invoked. So as a matter of statutory construction, all of the courts analyzing the statute, you looked at these essential definitional terms. So in New York, an adoptive child or adoptee means an adult or a child. The phrase "a person adopted" contains no age restriction. Thus, it encompasses minors and adults. Next slide, please. In New York, the adoption of adults has been expressly permitted by statute for over 100 years, and as explained in the case of Robert Paul P., which also went to the New York Court of Appeals, and Domestic Relations Law, Section 110, says that an adult may adopt another person, and it contains no restrictions on the age of the adoptee. Next slide, please. So in New York, just again, these are some really basic foundational materials just to kind of set the framework for our panel discussion. So in New York, jurisdiction to entertain adoption proceedings is in family court or surrogate's court. These courts are explicitly given jurisdiction. Supreme Court, of course, as a court of general jurisdiction, may entertain an adoption proceeding, but rarely, if ever, does. In our particular case, the Marion T. case, the case that was commenced in Otsego County Surrogates Court. Next slide, please. So Professor Bailey talked to us earlier about the best interest standard in Article 17A, and I think the professor cited Robert C.B., which talked about the best interest standard being amorphous. The adoption standard similarly has a best interest standard. Next slide, please. And then, although there's no specific guideline regarding best interest in an adoption proceeding, courts generally look to whether the respondent feels loved, safe, happy, and content, consistent with this line of cases. Next slide, please. So again, as a matter of statutory construction in New York, the Domestic Relations Law, Section 111, states that the adoptive child, if over 14 years of age, consent must be secured to the adoption unless the judge or surrogate in his discretion dispenses with such consent. And so this was really the crucial question in the Marion T. case, which again, just to back up, the agency I worked for, Mental Hygiene Legal Service, had been appointed as Marion's counsel in this adoption proceeding. The statute does not provide for the appointment of counsel. We happened to be appointed. I believe the judge appointed us because the judge was familiar with our agency and frequently adjudicated Article 17A guardianship proceedings. So when the adoption proceeding was assigned to the judge, he exercised discretion and appointed our agency to represent the respondent. So from our perspective, in terms of investigating the case and making a decision about whether to defend it, our concern was that the respondent in this case could not consent. She was a person with an intellectual disability, largely nonverbal, very engaging, very expressive, but very limited vocabulary, and diagnosed with a profound intellectual disability. So in many, as you'll see later in my presentation, one of the judges on the Court of Appeals, I stated that her consent was an impossibility. Next slide, please. So the slide earlier leads you to the statutory text, which states that the court may dispense with consent, and that language was added to our New York State statute in 1942. And so in working on this case, we at MHLS, we had investigated the legislative history and secured the bill jacket. And what we found in the bill jacket were statements in support of this amendment. And uniformly, from what emerged from the legislative history, at least to us, was that the court would be able to exercise its discretionary authority to dispense with consent in one circumstance. And that's how we argued the case. That's what we felt that the legislative history revealed. And that one circumstance would be where the knowledge of the adoption proceeding and discovery that the putative adoptive parents are not the child's biological parents would psychologically damage the child. So to the extent that the statute had any ambiguity and we needed to look to legislative history, we found this, what we thought was a persuasive purpose for the ability of a court to dispense with consent, but a very limited application. Next slide, please. So when we move back to Mary and Teen, we look at the what emerged from the Court of Appeals. It was a case that was decided five judges in the majority, one dissent, and one concurrence. The majority said, as a matter of statutory construction, that the statutory language does not restrict the scope of the court's discretion to dispense with adoptee consent, let alone reflect an intent to limit the exercise of such discretion. The courts expressly said, had the legislature intended to limit the judicial discretion in that manner, it would have said so in the statute. So that this is the majority reading of the statutory text. Now, and next slide, please. Judge Rivera wrote a dissent. She came to a different conclusion regarding legislative history. She said that the consent of the person subject to the adoption could not be dispensed with, and that the statutory requirement of consent would apply to all persons over the age of 14. Next slide. The Judge Rivera further stated that the state should not permit the adoption of individuals incapable of consent due to intellectual limitations. She observed that this is an evolving question, and that this really requires consideration of the adult individual's right to self-determination and autonomy, regardless of their capacity to consent. So the dissenting judge identified this as an evolving legal question. And then next slide, please. She concludes that the governmental body best suited to weigh these difficult policy questions is the legislature, not the court. And the dissenting judge felt that the majority exceeded its authority and crossed a line from interpreting a statute to redrafting it. Now, that leads us to the concurring opinion of Judge Wilson. And that's on the next slide. And Judge Wilson would not have disturbed the result. He he said the condition precedent of securing consent was an impossibility in this case, but he was otherwise satisfied that the adoption was in the person's best interest. So he would not have disturbed the result. But as I read the concurring opinion, the concurring judge was really reinforcing some of the concerns of the dissent. And on the next slide, it will be more apparent. The judge says, next slide, please. The judge says that that he could not disturb the factual determination that Marion's consent was an impossibility. And this is something, just as a reminder, the Court of Appeals review does not extend to questions of fact. So the Court of Appeals is reviewing questions of law. So the record is established, and the factual determination was that Marion's consent was impossible to secure, but he would have concurred in the result because of his thought or his conclusion that the adoption was in Marion's best interests. But on the next slide, he forces us to think about the fact that if we read this literally, it would be improper to read a statute that would actually dispense with the consent of an adult. And he provides a rather absurd example of what the slippery slope here is. He says, because we can't interpret the statute as written, we must construe it in a way that avoids unconstitutionality. Next slide, please. So Judge Wilson says that he's looked at this case and he comes to the in his mind the firm conclusion that the legislature really has never thought about this issue, this precise question. If a prospective adult adoptee is unable to give or refuse consent because of a profound intellectual disability, may that adoption proceed? And if so, what is required? And Judge Wilson and Judge Rivera are coming to the conclusion that this is really a legislative judgment, that the legislature should carefully consider these questions because adults with disabilities are not children. And this is often a consideration when we look at guardianship as well. Many parallels here, and we'll talk about it, I think, in the second hour, parallels between adoption and guardianship. But I think Professor Bailey started her presentation with this notion. There was a presumption maybe in 1969 that people with intellectual disabilities were children for life or perpetual children, but we've come a long way since then, and I think that's no longer the case. And I think Judge Wilson's concurrence is a very powerful reminder that adults with developmental disabilities are not perpetual children, and they might need adoption, potentially benefit from it, or guardianship, but the manner of simply dispensing with that person's consent, I think, is highly problematic. So next slide, please. So in thinking about, and I'm sure we'll get to more of this in the second hour, but what would be possible legislative responses? And I'm greatly benefited from some research that one of Professor Bailey's students had engaged in a couple of years ago. So I'm happy to share some of the results of that research. But 25 states in the District of Columbia allow for the adoption of a person regardless of age. But some states have different approaches. So for example, Colorado and Rhode Island allow for the adoption of adults, but only between the ages of 18 and 21. Nevada, for example, specifies that the adult must be younger than the adoptive parents. So in this case, our client Marion was older than her prospective parents. New Hampshire, another example. New Hampshire provides for the appointment of a guardian ad litem to protect the adoptive person's interests if the person's alleged to be incapacitated, mentally ill or developmentally disabled. And just a point here, briefly, in our case, the Marion T case, the court had actually appointed a guardian ad litem for the respondent, Marion, and the court impliedly determined that the guardian ad litem could provide consent for the adoption. When the case was appealed into the appellate division said no, that in New York, a guardian ad litem does not have that authority. So that's just a placeholder to think about some future legislative enactment. We might need to clarify the role of a guardian ad litem. Next slide, please. I highlighted this statute in particular, and we had briefed this as well. California has a statute that would have been right on point to the facts of this case. So in California, if a prospective parent is a provider of services to a person with disabilities, notice of the adoption must be provided to the regional center for people with developmental disabilities. And that center, our equivalent in New York would be the Office for People with Developmental Disabilities. But in California, that particular office would conduct an investigation and generate a report. So that's that statute would have, had we said something similar in New York, the statute would have been right on point. My final thoughts, at least as far as this part of the program is concerned, just broadly speaking, in my opinion, if there was legislative reform in this context for adoption of adults, I would urge that the statute provide for notice to the respective adoptee, the respondent. I would adhere to the requirement that there's consent. There must be consent. If the respondent in the proceeding was alleged to be unable to consent by reason of a disability, I would urge the appointment of counsel or guardian ad litem, some entity to protect the due process rights of the individual. I would urge a standard that's more precise than best interest, and I would advocate for an investigation. I think MHLS was clearly in the minority here. We, in our role as counsel, we actually felt two things. Number one, Marion could not consent. We also argued that the adoption was not in her best interest, and that flowed from our concern was that she, as a resident of a family care home, she enjoyed the protections of New York State law and regulations that once she was adopted were no longer, that protective framework was no longer available to her. And from our perspective, she didn't gain anything from being adopted. She was already living in this home, and she was in a family care environment. So we had maintained that the adoption was not in her best interest, but judges did not agree with us on that point. And so I think our view was certainly a minority in terms of that recommendation that we were making. So that's what I have now, and I'll yield the floor to our moderator.
Thank you very much. So I think we're going to move on to the second part of our discussion now, but I do want to, we did have one question in the chat that I just wanted to sort of quickly respond to, because it goes towards the overview, and actually, Rosemary, it goes towards your overview. So the question or the comment is, could someone say a few words about the environment of the creation of 17A? And gives an example. I think I'll start, Rosemary, and then I'm happy to have you lead in. You know, there have been other presentations that have been talking about 17A and the and what was going on sort of on the ground during the development of it, and why Article 78 was really driven from a family's perspective in a protectionist way for people with intellectual and developmental disabilities. So, you know, during this, period of time, this, the creation of 17A, and I think, Paul, you can also jump in here as well, the creation comes after some of the atrocities that were discovered looking at institutional care. Families were encouraged to place their family members in institutional models because that was where they were supposed to be cared for But once those kind of placements happened, the ability of families to remain involved and to advocate for their loved ones was diminished. Authority was given to the state schools to make some decisions. And as we moved towards deinstitutionalization of those individuals back into the community, some control was perceived as being needed to protect people from the abuses that they were subjected to while in institutional care. So I don't think anyone on this panel believes that there was some nefarious reason for the creation of Article 17A, but still there was some assumptions made about people with intellectual and developmental disabilities during the time that the creation of the statute happened, that bled into the actual language of the statute and the foundation for due process. And some of those foundationals are the things that you talked about, Rosemary, is the presumption about what people with intellectual and developmental disabilities are capable of, and what protection has to look like, and what a law to protect the rights of people with disabilities needs to look like, and the perpetual nature of being able to look at people with intellectual and developmental disabilities as static, as developing only to a particular point, and not continuing to experience and grow as individuals capable of self-determination throughout their life cycle. And so those are things, that I think I would want to emphasize. The panel is not vilifying the advocates that came forward to try to create the statute, but instead trying to put it in the context of what was happening during that period of time. And Rosemary, I'll let you jump in, and then Paul, if you want to jump in as well, feel free.
Sure.
Thanks, Jennifer. I saw the question as well. You said everything. It's great. I would just add that I think we're looking over a period of time. We acknowledge what transpired then, and I think to what Robert said, advocates to address the Sheila Puleo case and the type of situations by persuading the legislature to address those issues. And now and that was when the Family Healthcare Decision-Making Act didn't exist, and there were a lot of barriers to getting that law passed that Robert can speak more to than I can. But the point being that advocates did respond as they did it with respect to the situation in 1969. As time has gone on, the policymakers in New York recognize that things could be different. And we're urging that they not only acknowledge it, but take steps to make it happen, to do what we're thinking of now as the way things appropriately should be dealt with. And the supported decision-making statute is one example. I'm just saying that more could be done.
Paul, do you want to jump in?
Sure. Just to say that, I go back to those days when 17A was still under discussion and that sort of thing, I guess. And conditions at that point in time were, as Rosemary said, there was little or no response at the state and local level or at the federal level to the desire of parents to have their kids in some way dealt with by the educational system, some sort of program that would keep them from sitting around in the house. And then the alternative that was offered was developmental center living. And just one of the crushingly depressing things that I will take with me to my grave was going to all the developmental centers, including Willowbrook, where there was the Carl D. Warner Center for Kids, for infants, and seeing 3 babies under the age of 2 in chairs and 2 staff members there doing basic attentive behaviors and that sort of thing. And I guess my mission was to argue against their having 2 staff. And in fact, you have to walk away and say, no, they need 3 staff. Every one of these little kids needs somebody to do that. So when the Great Enlightenment came about in the 70s, there was an institutional population of I don't know, 30,000, a little north or a little south of 30,000 people. And, you know, you have to deal with that, even as you're doing the right thing for children being born or finally going through some sort of special educational program with an IEP and that sort of thing. You got to do something with the 30,000 people that you've left in institutions. And, you know, the state to some extent got indulgences from the federal government from meeting ICFDD standards in return for promising to close those beds. And, you know, that's mostly done now, but that was, you know, that was the environment. And I have to add to that just one other thing that may be slightly dated information. The unimaginably wrenching nature of the decision to place an infant or a young child in a developmental center led to a situation where the person, the last I worked at OPWDD, you know, probably more than 11 or 12 years ago, her estimate, she ran New York City operation, which was essentially half the state. And I asked her at a point in time, how many people that are in residential care in the community or elsewhere in the New York City catchment area have an actively involved family member? And at that time, her estimate was like 40%. And, you know, God willing, let's hope that the statistics are much more favorable than that now for people staying involved. But there are still all of these vestiges of the evils of the past, you know, which were products of clinical thinking at that point in time, that kind of weigh us down, I guess. That's enough.
And why policy decisions are made sometimes are not foundational. I think this goes to our first question. They're not always foundational in the things that we think of decades later they should be foundational in. And a lot of the discussions that you brought up as your talking points on these different statutory changes that you're proposing to be made come from the question of this, my kind of first question to the panel. What changes need to be made if we were thinking of this in terms of promoting the civil rights of the people with intellectual and developmental disabilities that are the subject of these laws as they are created? So if we were to flip the script and say we wanted to envision these laws from that, centrist position, what changes? And I'll have you kind of go around in a group. Rosemary, do you want to start us off?
Well, I think with respect to the guardianship, I think a decision has to be made as to what role, if any, Article 17A is still going to continue to play, because Article 81 covers anyone. So it's not as though we have a population that's been disregarded in our other guardianship statute. We have one that's fully there. I think some of the issue, and if you look in the chart of the choices about how to change the statute, they're virtually saying we're going to put in what Article 81 calls for. So I think I think that's, and I think the problems, and I know we'll talk about them, are not with respect to the substantive changes, except for one. I think the accounting, the post-guardianship appointment process is probably one where people differ. But as for everything else, it's basically, okay, let's take Article 81 and paste it over Article 17A. So I think that's where the legislature needs to confront that issue. That's my thought.
And Robert, I'll jump to you because I think you also have this same kind of problem that Rosemary is talking about having these two different statutes with a proposition of sort of putting them together. Why is putting them together, in your mind, a promotion of that civil rights versus a reduction of that right, which is often the argument for not putting the two of them together, right?
Yeah, no, that's a tough question. And I think it's less tough. It's easier with respect to extending Article 81 to kind of supersede 17A. You're adding due process elements to it that don't currently exist. And so it's pretty clearly extending the civil rights of people with developmental disabilities. When we get to healthcare decisions, I argued that it's a parallel to extend the Family Healthcare Decisions Act to people with developmental disabilities to treat them like everybody else. I think that is a kind of a human right. I'm not sure if it's a civil right, though, because I got to tell you, I have to admit, it's probably less due process than those people have currently. Because when you look at dying patients in particular, I don't conceptualize that as an adversarial due process type situation. Docs approach this and families approach this as a human problem about treating somebody at the end of life with compassion and with respect for families and with respect for an ethical imperative to try to determine the patient's wishes if known or else best interests and make that decision. But there's nobody coming there to deprive this person of their rights. That's not the scenario in an ICU or an ED. That I mean, with respect to treatment over rejection in mental health facilities, yes. But dying patient decisions, that's not a deprivation of rights type scenario. So yeah, if we were just looking at this through the lens of how do I amplify civil rights, I'd be saying, oh, well, what's my inventory of due process? Notice, opportunity to be heard, written decision, opportunity to appeal, impartial decision maker. I could dump lots of stuff on the dying ICU patient. It would be wrong. And I don't know that I can argue that Family Healthcare Decisions Act is going to increase, it's not going to increase the due process of these patients. It is going to increase the compassionate decision-making in healthcare for these patients. So, I'm owning up to maybe not having the best civil rights case here, but for a parallel treatment of this population with others.
Well, could we say that the civil right is to be treated like everybody else?
I am going to argue that. I was just owning up to the due process. If you conceptualize civil rights as adding due process, this doesn't meet that test. If it's treating everybody else like everybody else, and that's a good way to be treated, then I'm ready to make that case. Yeah.
I mean, the other thing that I think can be discussed here, which I think you came into your in your presentation, Robert, you talked about, is having a different standard creates in us humans a belief that there needs to be a different standard for people with intellectual. It creates an other category, right? So when you're at the end of someone's life and you're trying to train your clinical staff on how to treat people, talking about people differently makes people think they're different. And so what are the unintended consequences of that process? When the statute was created, it was for the betterment of more due process, but does it perpetuate a different thinking about people with intellectual and developmental disabilities? And what are the necessary protections? I think when you think about all these statutes, and I'll go, Sheila, to you next, it really comes down to when you're crafting something like a statute, what are the necessary protections to ensure the rights of people and ensure that discrimination doesn't occur? And when do we get it right? And when we get it wrong, how do we fix those issues? So Sheila, I'll go to you kind of next with that question of promoting civil rights.
Thank you, Jennifer. I was just writing some notes in terms of your original question about what's the centrist position, or what's in my mind as I'm thinking about adult adoption and also guardianship. And I'm reminded that we had gone through a considerable exercise at the New York State Bar Association Disability Rights Committee and you were really our leader, focusing us to think about these issues from a legal perspective, and recognizing that there's been such tension around statutory reform of 17A over generations or over decades. we identified what we thought were, I believe, 14 principles of guardianship. And so when you think about it in that framework, step aside from existing statutes and think about what would be the ideal. And we identified 14 principles of guardianship. So, and I think some of it carries over to the adult adoption discussion. So, but I feel from the central fundamental point of view is notice, and Robert touched upon these, the basic fundamental foundations of due process, notice, an opportunity to be heard, the appointment of counsel. I think those are absolutely fundamental and need to be included in a guardianship statute or an adult adoption statute. And thinking about, Robert makes so many good points about healthcare decision making, and I share so many of them, and I think Robert and I are not really that far apart. But MHLS, as people may know, does exercise an oversight responsibility in the 1750B context. I'm very comfortable with the notion that the statutes should be merged, that we'd have one healthcare decision-making statute. I think, as Rosemary alluded to, it should be in the public health law, not in the Surrogates Court Procedure Act. But I do feel strongly about the procedural, these safeguards that we talk about. Notice of a healthcare end-of-life decision, a life-sustaining treatment decision, to the mental hygiene facility director and MHLS. I have found over time to be a really crucial due process safeguard. And I hope not to put burdens on the patient and not to put burdens on the healthcare community, but just to ensure that efficacious treatment is being rendered, because over time, I have seen circumstances where there's a perception among healthcare community, the wider community, family members, there is this lingering perception that people with developmental disabilities have a diminished quality of life. And it's hard to even articulate that, but that does emerge even from some of the case law. And the oversight that MHLS is providing really is to ensure that efficacious treatment be provided. And if it's not efficacious to treat, then that there's dignity in the end of life. And I feel that 1750B really struck that balance. I feel that very strongly. But the statute, those protections could be included in a consolidated statute. And I think Robert and I agree on that there would be a way to do that and still emerge with one healthcare decision-making statute.
Paul, do you want to jump in here in terms of, because I see a divide, like a little bit of a divide. You have a adversarial process built into guardianship and even adult adoption, right? The legal system is sort of involved. But when healthcare decisions are made, it doesn't always fit itself into an adversarial process. And so when you think about what is the due process that emerges there, many of these decisions are made without, some type of, adversarial type of oversight. And so how does the promotion of rights of people with disabilities, how do we prevent that bias, Sheila, that you just raised in decision makings being made, without bias, in those processes that don't naturally fit into an adversarial situation?
Well, I promise that this is the last time, at least the last time I'll have an audience to make this argument, but it has disturbed me a little bit ever since the passage of the Family Healthcare Decisions Act, that both I guess what I call the incapacitated no and the presumption in favor of resuscitation vanished. And now they're not completely gone from statute, because the remains of Article 29C of the public health law still apply to state-operated mental hygiene facilities, and 1750B still places upon guardians or other surrogates that are empowered under that statute the duty to advocate for all efficacious treatment, including life-sustaining treatment. And so I think I can't defend Article 17A guardianships anymore, except to say that the elephant in the room there is the perhaps thousands of existing guardianships which family members in which family members filled the role of primary and secondary guardians. And somehow any solution has to have an implementation that takes those considerations into effect. And I can't disagree, and I think Robert makes a very strong case that 1750B could and should be folded into the Family Healthcare Decisions Act, except that there is some baby left in the bathwater in 1750B, in that there is still that presumption in favor of efficacious treatment. The old DNR statute at 2973 of the public health law permitted judicial review, quote, except that the decision of a patient not to consent to issuance of an order not to resuscitate may not be subjected to judicial review. And I can remember sitting in Governor's Counsel's office talking about what do you do about the incapacitated no? And it wasn't like an overwhelming thing, but I think we came out the right way there. And even though it may be anathema to people who administer hospitals, I think the incapacitated no, in other words, someone who wants for some period of time life-sustaining treatment can only be subjected to the argument of futility. And I just think I've seen futility argued in bar association tracts that came out of the pandemic and that sort of thing. And those are obviously food for thought. The other thing I guess I want to argue for is the continued involvement in a due process. There's too much due process in 1750B. If I recall correctly, and this has been eliminated, it was certainly something that should have been. There's a duty on the physician's part to notify every clinician in the hospital that was involved in the care of a physician of end-of-life decisions or a determination of incapacity. That's nuts. I mean, so there's probably too much due process. But what I think is not too much due process is the duty to inform residential facility directors of the determinations that are being made. And at best, maybe I just quit doing research at this point, but in the dissent to the Storer case in the Court of Appeals, there was an express recognition that for the first time in allowing Chuck Soper, who was the director of Newark Developmental Center when I was the general counsel there, to participate throughout this proceeding, that this was recognizing the right or the standing of a lifelong, probably lifelong provider of service as an extension of the state's parents patriae power. And, they had a right, and probably nobody knows more about an individual than the people who are providing residential services. So I just argued that that would have to remain in.
So before we jump, and I'll come back to you, Robert, for a response. I know, Sheila, you need to jump in here.
Yes, thank you. Thank you all. I'm chiming in to share the second code word for those of you who are seeking CLE credit. That code word is agency. You might hear this term in terms of a business, perhaps a state agency. We might also discuss this in terms of an individual's agency. So again, that code word is agency. Thank you.
So getting back to this discussion, I'm going to shift a little bit to I hear all of your passion for these changes that you're proposing that need to be happening, and I know this is a culmination of many presentations that the Government Law Center has done in this series. But the question that continues to pop into my mind is these discussions of the need for change have been happening for some time, but we haven't had these changes. So what is preventing change, and what does need to be done to achieve it? And I'll let anyone jump in to be the first to respond to that question.
Well, this is one of those situations where you don't know what you don't know. There are things that the unspoken. I mean, I've had occasions to talk to lobbyists and they tell you something and you say, okay, what are you not telling me? That what do we not know about this? So I don't know the answer, except I think that there is some lingering, the idea of protection and vulnerability of the individuals is seen that somehow the changes, say, to Article 17A are going to risk the vulnerability of the individual. I mean, I would argue that when a person is in a vulnerable state, whatever the reasons for that vulnerability, they deserve a lot of protection. And if someone is going to take away their rights to self-determination, they should be highly protected with respect to that. The other thing I think, though, it may be, and this, I've just sort of come to this recently, that we've actually been approaching these issues in silos. It's the silo of the Healthcare Decision-Making Act. It's the silo of the guardianship. It's the silo of the healthcare proxy. It's the silo of adoption. But the thread running through them all is the person with developmental disability. And we have a lot of policy language in this various statutes. It says, you know, go for self-determination. I think we need to make a presentation that it's all of one piece, that these various things of treating people differently because of this diagnosis shouldn't be the way New York should operate on the ground with respect to these particular statutes.
Oh, go ahead.
I also think that when it comes to 17A and 1750B, that the committee chairs and influential members and senators still go by the feeling that 17A and 1750B are children of the state ARC. The state ARC, when I left them, had somewhere around 102,000 members statewide, the majority of whom were parents and family members of people with developmental disabilities who were probably somewhere being supported in the service system, if not residentially, then through some sort of waiver services or integrated employment or something of that nature that the ARC was involved in providing. The chunk they took out of the New York State budget was somewhere in the neighborhood of, in Medicaid alone, I guess, somewhere in the neighborhood of $1.7 billion spread out among the, I think there's mid-40 number of chapters and that sort of thing. So I think a certain amount of leadership has to come from, they certainly have to be in the room and they certainly have to have a voice in whatever changes. And certainly a large number of the people who are members of the ARC of New York are 17A guardians, and their children are perhaps standby guardians for their siblings and that sort of thing. And, you know, that'll take some bringing along.
Mm-hmm. And one of the things that you raised, Paul, in your discussion was the impact of essentially going backwards to people who were appointed as guardians under a statute after you make legislative reform, or the same thing would be true, Robert, under the Healthcare Act, going backwards, and how do you remedy the problem of disruption? I know that one proposal that my organization put together to kind of to address the issue of, do you just invalidate, would the result of this would just be invalidating all guardianship that existed prior to the creation of whatever new process that existed with greater due process? Isn't, no, it wouldn't invalidate everything, but many times notice is sufficient, you know, to educate someone, a responsibility to notify them of their right to take action to create modification in their guardianship moving forward, or modification in their Healthcare Decision Act moving forward. So this is what it's going to be forward. So I wonder whether commenting on whether that is a barrier to sort of change, a belief, a lack of a belief that any disruption is going to, be impossible because of the number of people that find themselves currently under either guardianship or the healthcare decision making that's happening right now. And maybe Robert, you can jump in, because we had a shift, right? Healthcare decisions were made in one way, then a law was passed. How did we kind of correct ourselves as we add these protections in? And was that a barrier to adding those protections in when those laws were passed?
Well, I think the laws, if you look at Family Healthcare Decisions Act in particular, you were not able to get surrogate decisions for the mainstream population beforehand. You could for people with developmental disabilities, because general healthcare decisions were governed by reg and end-of-life decisions were governed by 1750B. So it was an expansion of decision-making authority that I think was generally welcome. It did require massive educational efforts, and hospitals and nursing homes live on forms. So it required the development of forms. Some adopted most as their internal form, many did not. Overall, I think it went pretty smoothly. I worked with others in creating a informational website that's still on the Bar Association, posted by the Bar Association, to help both the public and the professionals learn about the law. And now it is kind of interesting that the law itself is lengthy and somewhat complicated, but the provisions of it that are mostly referred to and used in practice are probably 2 pages. So, and the forms on that is probably 2 or 3 forms. And so staff got familiar with those very quickly. And it's only the unusual cases of so what do we do about this emancipated minor? Then you got to go look what the law or your policy says on that, but that's not the typical case. The typical case people got familiar with very quickly. What I was going to say is, yeah, if you were to fold the 1750B into Family Healthcare Decisions Act, that would require an educational effort and a shift in practices, and it would be a lift. But I think it would mostly be a one-time lift, and then people would be familiar with the replacement.
I could add something too on when Article 81 was enacted, there was an existing framework for what was known as committees and conservators. And like Paul was suggesting with Article 17A, there were a number of people who had committees and conservators. So the legislation addressed that by grandfathering those appointments into the statute. And then going forward, if there were modifications that needed to be made to the conservatorship by virtue of something that happened in that particular individual's case, then the court would apply the Article 81 findings to address that. But there wasn't, okay, we got to overthrow all of those existing situations. They were to continue as, as they were. And I don't know that there are any existing conservators or committees still left. I mean, that was many years ago, but there were for a while a number of cases that would come to court where there was a change. There needed to be a new person because the existing committee or conservator had died or had become incapacitated themselves. So I think it can be addressed. I think a larger issue for the guardianship is post-appointment situations and proceedings. The Article 81 provides for an accounting process, and the case that I included in the materials of Mark C.H., Judge Glenn, who was a surrogate in New York City, makes a very persuasive argument that a failure to have any kind of a quote-unquote accounting or follow-up with guardians is a violation of the rights of the individual who is subject to the guardianship. But I think, Jennifer, you and I and Sheila and Paul could agree that that issue is a very difficult one that needs to be looked at.
Yeah, I mean, and I'll let Sheila, you jump in as well, but it does go back to, like, if you were going to talk about the conservatorship, there wasn't an ongoing reporting requirement when 81 was created. So, you know, as it was folded in, the reporting requirement didn't get added until 81 had to act for that individual. So you had to, you know, you may be operating with the change in law with some people continuing to act under the statute, assuming reform doesn't happens as 17A exists now, and others, you know, acting within the, you know, the new law until they're sort of aged out of the process, right? That's, New York has had that experience. Many other states have had that experience as well when they've done reform, you know, in this area. Sheila, you wanted to jump in.
Going back to your question, Jennifer, about what might be some of the obstacles to reform. Why haven't we seen reform? And I just wanted to mention that you know, this concept of, you know, due process can be expensive, and I think that the right to counsel, for example, has been an issue. Like where would that, who would perform that function? Where would the funds come to support the due process that we're talking about? And I believe that in the program materials, did we include the Office of Court Administration program, Bill? Because you
Yes.
know, one of the Office of Court Administration has actually drafted a bill that would reform 17A and provide for the right to counsel, which envisions that the agency for mental hygiene legal service would be the counsel, unless the person had their own attorney, and that fits different models that, you know, MHLS is counsel in assisted outpatient treatment proceedings, or counsel in civil retention and voluntary treatment cases. So fitting into that model, MHLS could perform that function. But it is expensive, right? There's additional costs associated with it. And to Rosemary's point, I think what we haven't been able to solve conclusively is what would that model look like for a review of a guardian. Having a guardian report, I think, is an essential due process protection, but what does that report look like, and who reviews it?
Mm-hmm.
And I think from the surrogate court perspective, the surrogate court clerks may not have that infrastructure to take on that responsibility, and who could perform that function. So those are unanswered questions, but maybe they're obstacles to the reform that we're talking about. Should be questions we could answer and solve, but I think they have been obstacles.
I also think just as a practical matter, the surrogates court, and I don't know if the word like is the right word, but they like having these Article 17A guardianships. They feel like they've done something important for people's lives with Article 17A guardianships. And I think people like going to surrogates court. It's quiet, it's calm, it's not Supreme Court Manhattan, where I'm sure it's crazy all the time. So there's a certain something about the process that has nothing to do with the law, but it has to sort of do with the way things are, and changing the way things are. That can be an obstacle in and of itself, just changing the way things are. So that, plus I think education, I think we've seen with supported decision-making, there seems to be a fairly wide gap between what lawyers talk about when they talk about what needs to be done and what people who are dealing with this issue think they know about it, or what they've been told about it. And I think, Robert, you've alluded to this too, education for a lot of people is really important to make this happen. Because I think also, and I'll stop, but I think even some judges have this sort of mythology built around Article 81 of the mental hygiene law that they've adopted in defense of not changing the way things are. So I think we sort of need to work on that as well.
So Jennifer, can I add a point to that of why these things are difficult, at least in the area of, you know, the proposal I've been advocating? Really three things. One is, I couldn't agree more with Paul that legislators are not going to want to go against the view of the thousands of family members of patients who have developmental, or people who have developmental disabilities, And they have not advocated for this change. They just don't see it as in their interest until their loved one is in the hospital and is dying, and then they may be witnesses to all the difficulties that a different process creates. But there's no groundswell among that population for it. A second one is, we all know in Albany, it's way easier to block something than to make it happen. If there's any objection, legislators are going to be antsy about it. And then to compound that, I recently was on a panel with celebrating the work of Assembly Member Dick Godfrey, the Assembly Health Chair, who's just retired. And I was asking him why it's been so difficult to get some other really simple changes to Family Healthcare Decisions Act, typo corrections, and a few other changes to make language consistent in this section and another section. And he said, my colleagues just don't want to deal with these end-of-life issues. There's no payoff for them in it. And it's just controversy, and they just steer clear and start walking down the hall when you try to talk to them about it.
You can't hold a press conference and say, we struck a goal for dying today.
On the other hand, a lot of them who opposed healthcare proxy, if you go into their offices, they have healthcare proxy forms in their little kiosks and are now like promoting it. And that's been, despite some of Paul's criticisms, we could do another panel on that. I think that has been a very successful initiative. But they don't like talking about this. There isn't any groundswell of support. It's just the nerds who deal with the stuff that you're referring to. I don't think you said nerds, Rosemary, but who are dealing with this.
But that's what I meant,
The
right?
ones who are dealing with this are the ones that see the difference.
So just to add a couple of positive things instead of being Mr. Problems with implementation.
Okay.
I think what's been said about the surrogate courts, all of those things are accurate, but as someone who's riding off into the retirement of watching game shows and stuff, I'll be bold enough to say that in my experience in trying to deal with surrogates courts individually, in dealing with their associations among themselves, and in dealing with OCA, there's some pretty substantial resistance among surrogates generally to being overseen by OCA, and that's a reality. And of course, there are lots of surrogates courts downstate where there's not only a separate surrogate, there might be 2 or 3 or 4 surrogates in those courts, and there are a whole bunch upstate that are all 3-hat judges, where they probably don't even have a clerk that has the experience in dealing with 17A, and not all the forms that OCA populates their website with accurately reflect 1750B. But I think what could be done as an approach is to confer perhaps upon surrogates, who some of whom seem to have more time on their hands, make them the receptacle for guardianship applications in an area. There's a guy up in Rensselaer County that does that and loves doing it. Judge Guy, surrogate Guy, who was on our last panel, enjoys doing that. And by integrating their experience, maybe they would take some ownerships over these conflicts in statutes and the disparity in due process and that sort of thing. And maybe some change could come about that way. And I have one final.
Could I just, before you get to the next one, could I just hop in and agree? I think that acting supreme is a possible solution, because that key that the respondent has no power to move out of the 17A, if it could be done, to create a judge who's an acting supreme could then handle an Article 81 if the respondent so moved and said, I'd like to be dealt with under that statute. So I'll let you go. Sorry for jumping on, but I thought that
I just had one nit to pick, which is, I think when the statute goes forward to at least integrate 1750B into the Family Healthcare Decisions Act, which I think, is doable, Robert, within your lifetime anyway, or working lifetime, perhaps not within mine. But one of the things that ought to be dealt with is an integrated definition of life-sustaining treatment. There's a present definition of CPR, which excludes any measures taken employed in the absence of an arrest, a respiratory arrest, or a cardiac arrest, which to me, and in dealing with this, and it's been a while since I dealt with this on a weekly basis, but it kind of creates a lot of confusion. I just don't think there's any need for that anymore. And also, the last time I looked, although there was a perfectly fine definition of DNI on the most form and in the explanatory materials, I don't believe there's a statutory definition of that. So I would argue as an element of a bill of that sort, some other things being in it, hopefully that would not weigh it down, where the imperative behind them is not controverted, and an integrated definition of life-sustaining treatment might help.
So we've come to the end of our panel. I did want to make one response to a question in regards to education. And I think it follows up on Rosemary, some of the things you've said, Robert, some things you've said, that many people who find themselves pursuing guardianship are encouraged to pursue that guardianship under the myth that it gives them the certain authorities to involve themselves in decision making, that they later find out it doesn't give them that authority. And so holding on to the myth is one of the barriers to getting reform. And certainly the point being made in the question about effective advocacy needing to be led with education. So I appreciate the comment. Leslie, or Judge Stein, do you want me to turn this back to you to close us out for the day?
Sure. I really want to thank you, Jennifer, and all of our panelists. Each one of these programs just seems to build upon the past ones, and so many important ideas and experiences are brought to the table here. And it's clear that we still have a lot of work to do, and you all are doing so much of it so well. And we'll continue on. So thank you to you and to all of our participants.
Thank you.
Cool. Pleasure.
Thank you.
Thank
Pleasure
you all for
always.
joining us today. For those of you seeking CLE credit, you should have received your CLE forms and program materials by email. You will need to submit your CLE forms to Lisa Rivage in the next 24 hours. Her email is lriva@albanylaw.edu. And I'm going to share a couple more slides for those of you who want to stick around and learn about some upcoming events we have as well.